Hello, everyone. Welcome back to our channel, U.S. Immigration News. Supreme Court set to decide the future of birthright citizenship. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. When Donald Trump returned to the White House in January 2025, one of his earliest and most controversial actions immediately reshaped the immigration debate. Within days of taking office, he signed an executive order aimed at restricting birthright citizenship, a principle that has long defined who is considered American. The order sent shockwaves across immigrant families, legal circles, and constitutional scholars, raising urgent questions about citizenship, parental status, and the reach of executive power. What changed under Trump's executive order? Under the executive order, any child born in the United States after February 2025 would be recognized as a U.S. citizen at birth only if at least one parent was either a U.S. citizen or a lawful permanent resident. This marked a sharp departure from decades of practice. As a result, children born to parents who are undocumented or who are in the United States on temporary non-immigrant visas, including tourist visas, student visas, or work visas, such as the H-1B, would no longer receive automatic U.S. citizenship at birth. Courts stepped in almost immediately. The executive order did not go unchallenged. Lawsuits were filed almost instantly, and federal courts stepped in to halt enforcement. Judges issued temporary stays and nationwide injunctions, preventing the policy from taking effect while its legality was reviewed. Those early court actions bought time, but they did not resolve the underlying constitutional question. Supreme Court takes up the case. In a major development, the U.S. Supreme Court has now agreed to hear the case. The justices will decide whether Trump's executive order is constitutional and, more importantly, whether the 14th Amendment guarantees citizenship to children born in the United States when their parents are neither U.S. citizens nor lawful permanent residents. A final ruling is expected by June 2026, and its consequences could reach far beyond immigration law. A critical assurance for parents. One point is absolutely clear and deserves emphasis. The executive order applies only to children born after its effective date in February 2025. It does not apply retroactively. If your child was born before February 2025, that child remains a U.S. citizen regardless of how the Supreme Court rules. Parents who have been waiting for their U.S.-born child to turn 21 and petition for them do not need to fear that their child's citizenship will be taken away. That will not happen. The 14th Amendment at the center of the storm. The legal battle centers on the 14th Amendment, adopted after the Civil War. It states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Trump argues that this amendment was designed to secure citizenship for children of formerly enslaved people and that it has been wrongly expanded to cover the children of undocumented immigrants and temporary visitors. The meaning of subject to the jurisdiction thereof. Trump's interpretation focuses heavily on one phrase, subject to the jurisdiction thereof. Historically, this language excluded children of foreign diplomats, who are not subject to U.S. law in the same way as ordinary residents. Trump extends that reason to argue that people who are out of status or in the U.S. on non-immigrant visas remain loyal to their home countries and are therefore not fully subject to U.S. jurisdiction. Under this view, their children would not qualify for birthright citizenship. The 1898 Supreme Court case in the spotlight. Opponents of the executive order rely heavily on an 1898 Supreme Court decision known as United States versus Wong Kim Arkansas. In that case, the court ruled that a child born in the United States to Chinese parents was a U.S. citizen at birth under the 14th Amendment. Many argue that this case settled the birthright citizenship question once and for all. Why the legal picture is more complicated. Trump supporters respond by pointing out that the parents in the Wong Kim Ark case were lawful, long-term residents of the United States. Trump's executive order explicitly preserves birthright citizenship for children of lawful permanent residents, which allows his administration to argue that the order is consistent with the 1898 ruling. Because of this distinction, the constitutional arguments on both sides are not as straightforward as they may appear. Why this case could reshape the nation. If the Supreme Court upholds Trump's executive order, the United States could see a fundamental redefinition of citizenship. Birthright citizenship would effectively end for children whose parents are neither citizens nor green card holders at the time of birth. Such a decision would reshape immigration policy, family-based immigration pathways, and the meaning of citizenship itself for generations to come. A word of caution for families right now. If you are out of status and have a child who is 21 or nearing 21, it is wise to consult an experienced immigration attorney before filing any petition or application. Eligibility rules, documentation requirements, and adjustment options can be complex, and even eligible individuals can face serious risks if a case is filed incorrectly. Supreme Court to rule on Trump's bid to end birthright citizenship. The U.S. Supreme Court has agreed to hear a pivotal case that could reshape one of the most fundamental principles of American citizenship: whether President Donald Trump's effort to end automatic birthright citizenship is constitutional. Arguments are expected in April, with a decision likely by the end of June, setting the stage for a historic ruling, a day-one executive order that sparked national uproar. Just hours after being inaugurated in January, Trump signed an executive order declaring that children born in the United States would no longer be automatically granted citizenship if their parents were undocumented immigrants or foreign nationals on temporary visas. Trump argued the policy was necessary to deter illegal immigration and prevent so-called birth tourism, in which expectant mothers travel to the U.S. to secure citizenship for their children. The order fulfilled a major campaign promise, but it immediately triggered legal challenges nationwide. Federal courts blocked the policy. Within days, federal judges across the country halted the order, ruling that it conflicted with the Constitution and long-standing Supreme Court precedent. Judges pointed to the 14th Amendment and the landmark 1898 case United States versus Wong Kim Ark, which has long been understood to guarantee citizenship to nearly everyone born on U.S. soil. As a result, Trump's policy never took effect, a strategic pause before the high court battle. Rather than immediately asking the Supreme Court to revive the order, the Justice Department initially focused on a related issue: the power of lower court judges to issue nationwide injunctions. In March, Solicitor General D. John Sauer urged the justices to curb that authority. The move delayed a direct ruling on birthright citizenship for nearly a year. In June, the Supreme Court limited but did not eliminate nationwide injunctions, leaving the core citizenship question unresolved. Administration renews its constitutional argument. In September, the Trump administration returned to the Supreme Court, asking it to rule directly on the constitutionality of the policy. Sauer argued that the 14th Amendment Citizenship Clause was intended to grant citizenship to formerly enslaved people and their children, not to children of undocumented immigrants, temporary visitors, or birth tourists. According to the administration, birth on U.S. soil alone was never meant to be sufficient. Critics warn of legal and practical chaos. Opponents argue the policy would upend more than a century of settled law and raise serious questions about presidential authority. They also warn of logistical chaos, noting that birth certificates are issued by states and often do not record parents' citizenship status. Democratic-led states told the court the order threatens equality under the law and full citizenship for those born in the United States. While the policy does not revoke existing citizenship, critics say its legal logic could cast doubt on the status of millions of Americans, making this one of the most consequential cases of the decade. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care